I'm with Andy Osborne of Northern Trust, and the question that I've got from Andy is due diligence. How is it actually changing?
Thank you, John. Due diligence, it's something people think about, and they tend to think about it in very narrow terms. Due diligence, it's more than a one visit per year to an agent bank. A due diligence, it's an enterprise-wide effort by the organisation. So our due diligence exercise includes our credit guys, legal guys, compliance, anti-money laundering, business continuity planning, with network being the epicenter of this enterprise-wide exercise. It's not a one-off exercise, it is a way of life, and it ensures that we are able to demonstrate our ongoing commitment to the safety of our client assets to our clients and our regulators.
Tell me, as far as the due diligence exercises you do as a network team, do you communicate them and the results of them actively to your clients?
In broadest terms, yes. Clearly, if we had any issues, we'd be seeking to deal with those issues, but we've taken those out of the system over time with the work that we've done. These exercises are clearly documented and supervised by our internal governance bodies.
And are clients interested in the due diligence process? Do they question you a lot about your agent network?
More so than you'd think. Until 3 years ago, it had almost fallen off the edge of the map. But over the last 3 years, asset safety has become of paramount importance to clients, and rarely does a client visit or a prospect visit go past without the subject of our agent bank management and monitoring program coming up for discussion.
I mean, obviously cash is held through your bank. The assets are held as a fiduciary. Mm-hmm. And although in some countries the law on fiduciary is clear, in other countries it is somewhat hazy. I do appreciate that you go to Baker McKenzie and you get their no action letters, but is that sufficient to protect you against a loss in the event of a problem arising?
There are no absolutes, John, I think is the bottom line to that one. And even if you would have assets registered through the system into the beneficial owner's name, that may not offer any guarantees in the event of particular type of actions taking place in the market. There could be governmental seizure of assets. So all we can do is undertake reasonable efforts to secure the safety and soundness of the client assets through the legal opinions, identify any gaps and make sure that we can action them or bring our clients or bring them to our clients' attention. And if we're not satisfied with the safety and soundness arrangements in a market, we would not offer our services there.
I mean, are there markets, and I know I discussed this a long time ago when I was involved with some clients who invested in marginal markets, are there markets where you will say exclude certain other protections that you give to clients and only deal in those markets on the basis the client recognizes the added risk they're taking?
We used to put a lot of work into creating side letters, side agreements with clients for certain markets, but this caused a lot of angst with clients. So we had a long, hard look at the content of those agreements, and we became very comfortable with the fact that such agreements were broadly covered in the existing contractual arrangements between us and our clients. So what we would do then is, rather than have a separately executed agreement, we would provide sort of a written warning, health warning on the market to clients, and draw attention to the fact that these issues would be covered in the existing contractual arrangements. But there is one market we've opened recently where we do offer a lower than typical standard of care, because we're going with the best available provider in the market that wouldn't normally meet our requirements.
Andrew Osborne, thank you very much indeed.
Thank you, John.
Thanks very much. That's
Cheers.
Great.